Hello, and welcome to the first of 3 audio recordings of articles I've authored on using letters of credit as a credit enhancement tool. I'm Ray Patella, and I'm an attorney with Kramer Burns, a full-service law firm located in northern New Jersey, primarily serving business clients in corporate matters, commercial transactions, real estate, litigation, and bankruptcy creditors' rights. We also assist individuals with estate planning and residential real estate needs. I practice in the areas of creditors' rights, insolvency, bankruptcy, distressed transactions, and litigation and other business law matters. Credit professionals often act as checks and balance against their sales department's potential risky attempts to bring in new accounts in their yearn for revenue. The credit department is responsible for evaluating the risk proposed by a new account and suggesting ways to either minimize that risk or enhance the creditworthiness of the new applicant. There are various ways to enhance the credit of an applicant at the beginning of a relationship, including a cash deposit, a lien on the collateral provided to the customer, requiring either prepayment or cash before delivery, providing goods on consignment, insisting upon shortened payment terms, obtaining guarantees on affiliates or the principals, and obtaining credit insurance for the account. This first of 3 sessions focuses and provides a background on letters of credit, or LCs. Future sessions will discuss the advantages of them as a credit enhancement tool and how draws under a letter of credit can be prevented both inside and outside of a bankruptcy. Letters of credit are a method of shifting the credit risk from the customer to a financial institution issuing the letter of credit. There are 2 types of letters of credit. The first is commonly called a commercial or documentary letter of credit, which is generally referred to as a direct pay letter of credit and is used mostly in international sales. To illustrate, assume a buyer in New York wants to buy furniture from a seller in Germany. Because the German seller does not want to sell on open credit, and the New York buyer does not want to pay the seller in advance, the seller, here the beneficiary, would insist that the buyer, the applicant, produce a commercial LC issued by a bank, the issuer, showing the seller as the beneficiary with the right to draw upon money or the draft on the issuing bank directly rather than the New York buyer. How does this work? The New York buyer applies for an LC, which commits a bank to pay money to the German seller upon the seller's presentation of certain documents that are outlined in the LC. These documents generally describe the goods in accordance with the LC or include an invoice, policy of insurance, and/or a certificate of inspection. Once the seller's documents comply with the LC, the bank would pay the seller. The LC compels the bank to pay the money to the seller even if the buyer thinks the furniture is inferior and otherwise instructs the bank not to pay. After the bank pays the seller, the LC would force the New York buyer to pay the bank even if the buyer might not be satisfied with the seller's goods. If the buyer is not satisfied with the furniture, then it would have to take legal action directly against the now fully paid seller. The second type of letter of credit is commonly called a standby letter of credit. This differs from a commercial LC in that the beneficiary uses the LC to secure the performance of its customer rather than to obtain a direct payment for the customer's obligation. This is the type of LC credit professionals typically use for domestic business. Standby LCs function somewhat like collateral because the applicant's default on its obligations prompts the beneficiary to draw on the LC. To illustrate, assume a customer agrees to pay for goods or services that the vendor provides. If the customer fails to pay, an event of default occurs under the customer-vendor contract. This event of default should entitle the vendor to draw on this standby LC. According to the standby LC, the issuer bank would pay the vendor beneficiary when the bank receives a written statement certifying that the applicant customer failed to pay the vendor. Next, I will discuss the basic principles of a letter of credit. An LC transaction is a three-party arrangement between the issuer, generally a bank, the applicant, a customer, and the beneficiary, the vendor. First is the relationship between the applicant and the issuer. This usually entails a reimbursement obligation between the issuer and the applicant, requiring that the applicant reimburse the issuer for payments made on the LC to the beneficiary. Second is the relationship between the applicant and the beneficiary. And finally is the relationship between the issuer and the beneficiary. This third relationship is reflected in the LC itself, which is the undertaking between the issuer and the beneficiary. The uniqueness of an LC arrangement is the independence principle. This rule of credit law is central to the understanding of the importance of LCs. The principle states that the issuer's obligation to the beneficiary is independent of the beneficiary's performance on the underlying contract. In other words, the issuer should pay on the LC on a proper demand from the beneficiary, even though the beneficiary might have breached the underlying contract with the applicant. Also, the issuer's obligation to pay the beneficiary is independent of the applicant's obligation to its issuer. For example, if the applicant goes into bankruptcy after the bank issues the LC, but before the beneficiary draws on the LC, the issuer should pay even though the applicant may not be able to pay or reimburse the issuer. The LC beneficiary is obligated to present conforming drafts or documents. Once the beneficiary does that, the issuer must honor the draft or demand for payment. However, the issuer should deny payment if the beneficiary does not present the proper documents or drafts to the issuer. Determining whether the documents the beneficiary submitted comply with the LC, however, is not clear. The drafters of the Uniform Commercial Code deliberately left this matter to case law and practice. Two standards of compliance exist. One is the strict compliance standard. Strict compliance holds that the beneficiary should comply strictly with the terms of the credit, and that any failure of the documents or draft to conform excuses the issuer from its duty to honor the beneficiary's payment demand. The other standard is substantial compliance. Under this standard, the issuer is required to pay the beneficiary if the beneficiary's documents substantially or reasonably comply with the LC. The majority of case law prefers the strict compliance standard. To avoid a problem situation with the issuing bank, the LC should be simple and clear on its face, and the draft should track the language of the LC. In conclusion, we have discussed the background and underlying principles of letters of credit, including use in commercial and international transactions, types of letters of credit, and the independence principle. Vendors and other parties in complicated commercial transactions are advised to seek the advice of counsel to minimize credit exposure in any given transaction by ensuring that the proper letter of credit is in place. Please tune in to the next session in this series, which will address why letters of credit are preferred over other forms of credit enhancement available in a commercial setting. In the interim, thank you for listening to this update, and please contact me at 973-912-8700 or via email at rpatella@kramerburns.com. I'm pleased to answer additional questions and discuss your specific situation.